that I don't see any emergency circumstances that would have necessarily justified an expedited hearing in the case. I really don't see that the allegations that he has alleged constitutes an emergency.
First off, respectfully, we would disagree that this is not an emergency situation. He has gone without parenting time for 25 days.
Versus Zach Rodriguez, respondent. It is case number 2019 DM 298. Petitioner apparently appears along with his attorney, Alexander Vasquez. Eric Kidwell appears as counsel for the petitioner in this case, the mother. Where is she located, Mr. Kidwell?
She's seated right behind me in this Zoom recorded hearing.
All right, I now see her. I also have named Haley Dunn on this meeting.
Haley Dunn, one of our exhibits was a witness statement from Miss Dunn, who was there when all of this occurred. So she's present in case the court has questions or if the court will allow me to ask her what happened.
All right, very well. It's the court's understanding that this was originally scheduled as hearing on an emergency motion that Mr. Rodriguez initiated on his own, noting, of course, he designated this to be in the District Court of Sedgwick County. I think this case is actually in Butler County, and his motion probably should have been rejected by the clerk's office for an improper caption, but nevertheless, it was accepted for filing. The court's aware of it. I've read the motion and I could just make the initial statement is that I don't see any emergency circumstances that would have necessarily justified an expedited hearing in the case. While I don't make light of his loss of parenting time for any reason, I really don't see that the allegations that he has alleged.
And right away, the judge makes the first major call, and it's not what the father wanted to hear. The court says losing parenting time is serious, but that alone doesn't automatically make a case an emergency. In fact, the judge suggests the mother's concerns about the child's safety may have been a real emergency. That sets up the central battle of this hearing. Was the mother protecting her child, or did she go too far by stopping court-ordered parenting time on her own?
Constitutes an emergency. Rather, the court is of the belief that the mother's protection of the child very well, or her efforts to do so very well, may have constituted emergency circumstances. But obviously that it's not her motion that we have before the court. We are where we are. The matter comes before the court at this time. The court is generally aware of each party's position in the matter. Mr. Vasquez, I know you're apparently new to this case. You didn't file this motion. Your client did. What is your position on behalf of Mr. Rodriguez at this time? What needs to be done?
Well, Your Honor, first off, respectfully, we would disagree that this is not an emergency situation. He has gone without parenting time for 25 days, starting July 17th. He has joint residential custody, Your Honor, and I have prepared a presentation to address the facts that led us here today, if the court would allow.
You may.
Thank you, Your Honor. Your Honor, so there are certainly some serious allegations being discussed here today, and we don't intend to minimize any of them. But I think it's important from the outset to distinguish between two very different questions. The first is whether respondent took appropriate action when he learned that there had been inappropriate behavior occurring between the children in his household. He did. Second is whether those allegations gave petitioner the unilateral authority to suspend his parenting time, court-ordered parenting time, indefinitely. They did not. Your Honor, when respondent learned that the children had been, Your Honor, there was an incident here. It happened in October. He found out, he walked in, he saw them underneath a blanket. And he immediately panicked. He separated the children. At that point, they were sharing a bedroom. They had bunk beds. Your Honor, these are children. At the time, it was 4 years old and 6 years old.
5 years old.
5 years old
And 7 years old.
And 7 years old. When he learned that happened, he immediately separated the children. That same day, I think an hour later, he went out and purchased separate beds so that the children would no longer be sleeping together. He made it a rule to where they can't be together unsupervised anymore. And they are essentially, he had a talk with the child. He didn't want to traumatize the minor child. Again, this was to him at this point, this is the first time an isolated incident, first time it happens. These are children. Importantly, Your Honor, there's no allegation that respondent himself engaged in any inappropriate behavior with the children, with the child. There's no allegation that he encouraged this behavior. The issue involving the children was identified. He intervened. He changed the sleeping arrangements to prevent it from happening again. Again, he took each child, discussed why that was inappropriate. He made rules. He made it a norm where they couldn't be together and by themselves. They weren't to be allowed unsupervised. They weren't allowed to be behind closed doors, but unsupervised in the same room. What happened in July is different. Petitioner learned about the prior incident and made the decision that she, not this court, not DCF, not law enforcement, not the PFA court, she would determine when dad would continue seeing his daughter. She started withholding the child July 17th. Again, she made all these reports. There's an active Roseville Police Department report. There's an active DCF report. She filed a PFA. She did everything except ask this court for relief.
Now, the father's attorney is building his defense around one key argument. When Dad discovered the inappropriate behavior, he says he didn't ignore it. He acted immediately. Separate beds, separate rooms, no unsupervised contact, and conversations with the children. But here's where this case gets complicated. The mother says the bigger problem wasn't just what happened between the children. It was what Dad allegedly failed to tell her. And in a shared custody case, that communication issue could become just as important as the original incident.
And all these organizations, all these investigations going on, no authority has determined that he is unfit to parent or that he acted inappropriately. So despite utilizing all those available mechanisms, there's still no orders suspending his parenting time, yet she continued to withhold the child. That's why we're here today. Again, Your Honor, I want to be careful about the terminology being used here. We are talking about two very young children. These are 5 and 7-year-old children. Their ages matter. Their ages matter when the court evaluates about the conduct and Dad's response to it. We're not suggesting that inappropriate touching between children should be ignored. It shouldn't, and it wasn't. When Dad learned about the inappropriate behavior, he took it seriously. But there's a significant difference in acknowledging inappropriate behavior between two young children and immediately assigning adult concepts and adult motivations behind that behavior, Your Honor. So what did Zach do with what did he do with that information? Dad intervened. He explained that it was inappropriate. He made sure the children would no longer share a room. Again, he established rules that these children should not be left together unsupervised. Those restrictions still remain active today. So I disagree fundamentally with petitioner's characterization that he failed to protect the minor child. He identified a problem. He identified a problem with two young children, implementing concrete safeguards designed to prevent it from happening again. Your Honor, there was an incident that happened in July. And again, we're here to be transparent. There was an incident that happened in July with the minor child of the parties here. It didn't involve his stepson, Cincinnati. It did involve another child while in petitioner's care. And Ms. Dunn is here today. She provided a statement, and I'm sure she could clarify what happened that day. But essentially, the minor child was in a similar situation with another little boy in petitioner's care. I mean, the facts are laid out in both the motion and the response. They interviewed Ms. Dunn apparently interviewed the child. She said, yes, my dad has gotten mad at me before for doing this. He talked to me. It happened. They called Dad. Dad immediately said, yes, I absolutely. I thought it was an isolated incident. In retrospect, he should have made Mom aware. But again, to his understanding, this was an isolated incident that happened once. It hadn't happened since. He took the safeguards needed to protect the children. And he acknowledges that he should have reached out to mom. He should have reached out. He should have made her aware. But hindsight is 2020. We're here now, and he's taking this very seriously. He immediately sat down with mom and her new husband. They talked about therapy. He said, absolutely, now this has happened again. She needs to be in therapy. We need to do whatever it takes to make sure, this doesn't happen again, to make sure that all children are safe. So the child's in therapy. Immediately, what happened here is that the blame became that the blame became that this happened because of him, and she allowed it to happen. Your Honor, that's not what happened here. Again, these are children. When he saw it, he acted in what he believed was the appropriate measure. What happened after that was, again, mom, starting on July 22nd, unilaterally refused to withhold a minor child. But actually, she said, you can have visitation of a minor child, but I need to have your location on my husband's phone. We need to be able to track you. How that's relevant or synonymous to the situation that happened, I'm not sure. She started creating her own orders. She started creating her own restrictions. She contacted the Rose Hill Police Department. The police department, Dad called the police department. They investigated the police officers, and I believe that's our Exhibit F, Respondents Exhibit F, and it's page 29. The report by Officer Zachary Hobson. The officers told mom that they would not condone her violating a court order. They told her, this is not the appropriate remedy. You need to go to the court, ask for relief. We're not condoning you violating a court order. Yet she continued to withhold parenting time. She filed a PFA against the little boy. It got denied. She was asked, and in that PFA, which is in our exhibit D, is a petition for the PFA and a summons. She requested sole legal custody. She requested supervised visitation. Again, it was denied. She has continued to unilaterally deprive respondent of parenting time here.
I would object with the statement that it was denied. It's going to be heard, as you know,
the temporary
this
orders
month.
were denied. She did not get.
And it was only denied because she named a child and didn't have an attorney and didn't know to name the parent involved. So it's not been denied. It's set for hearing.
Temporary orders was denied. Relief was denied. The only court orders enacted at this point in time are the one awarding Dad to have joint residential custody, Your Honor. So, Your Honor, she was free to file an emergency motion with this court. She was free to file the PFA. She was free to file an investigation with DCF, which has been investigated to Dad's knowledge. What she was not free to do was appoint herself as a judge. She could not simply decide, I believe there's a safety concern, therefore the existing parenting plan no longer applies. Your Honor, again, they submitted a video for this court to consider. We have watched the video, and he says in the video, he sits there apologetically and says, hey, I had no way of knowing it would happen again. I thought I handled it. I thought I put all the safeguards, and it hasn't happened again in his household. It happened again in petitioner's household. And granted, had he advised her, would she have not left the children unattended? Absolutely. But to his understanding, this has never happened before. It never happened before. He's always had joint residential custody for all of the child's life. He has never witnessed a similar incident with his child. He had no way of knowing that it would continue to happen. He had no way of knowing that this event would trickle down to the July event with Ms. Dunn's child. So in the video that was presented for evidence before this court, Dad was attempting to de-escalate. He said he took full accountability of the fact that he should have let mom know. It was a poor lack of judgment, and I think this court would agree. he immediately acknowledged the fact that the child needs to go to therapy. He acquiesced to whatever he needed to facilitate that. And he contacted law enforcement whenever she deprived parenting time, Your Honor. So here dad has tried to do everything to de-escalate and try to do everything to prevent this situation from happening again. Your Honor, this was for lack of a better word, a tragedy that happened and that happened again in July. He takes full responsibility for his poor lack of judgment of not contacting mom. But he used his judgment. He thought that he was acting within his, right as a parent. He pulled them to the side and he thought he handled the situation. And Your Honor, this demonstrates his willingness to act in the best interest of the minor child. Your Honor, we have submitted text messages and respondents exhibit G of petitioner refusing parenting time. Almost every single day since July 22nd, he has reached out and said, hey, I need to see my daughter. She needs to see her father. What's going on? Why can't I see her? She's been unilaterally refusing to exchange the minor child. She knows that the safeguards are in place where neither child is going to be left alone. And quite frankly, the child shouldn't be left alone with other children in either home, pursuant to the accident that happened with Miss Dunn's child. And that's not good enough for her, Your Honor. So really, we're asking for this court to reinstate his parenting time and to acknowledge the fact that it's in the child's best interest to have meaningful relationships with two parents. This has been a traumatic event with the child. She is now seeing a therapist. She's been yanked apart for the status quo of her having meaningful parenting time with each parent. Now she's in therapy. This has shifted her whole world. We strongly believe that it's in a child's best interest to have respondent's parenting time restored. Your Honor, if the court has any continuing concerns about interactions between the minor child and his stepchild while the investigation occurs, he is prepared to abide by reasonable safeguards, the same safeguards he has already implemented, that the court can order that the children remain separated. The court can require separate sleeping arrangements, which is already implemented. The court can prohibit unsupervised contact between the minor child and the other minor child, which again is something already implemented. But none of those measures require depriving the minor child from time with her dad. There's less restrictive solutions available, and respondent has demonstrated his willingness to implement it. Your Honor, so to wrap up, respondent is not asking this court to ignore what happened. He's asking the court to look at what he did when he learned about it. These are two young children, 5, 7. He acted, he bought separate beds, posed rules, told the child separately, talked to them. Could he have communicated with Haley sooner? Absolutely, he should have. But a failure to communicate is not a failure to protect, and it does not make him a danger to his daughter. Petitioner had concerns. She had every right to report them. She contacted law enforcement, DCF, pursued a PFA. But reporting a concern does not give her the unilateral right to rewrite a court order. And I think that's the fundamental disconnect here, Your Honor. The alleged conduct involved another child, but her solution was to remove father from her daughter's life. Corporate safeguards are justified. Unilateral suspension of father's parenting time is not. And until this court changes its order, the order is not optional, Your Honor. We ask this court to enforce it. Thank you. Nothing further.
Mr. Vasquez, you mentioned earlier as part of one of the options for the court, separating these two children. What did you mean by that?
Separating no unsupervised contact, Your Honor. Separating them. They're already separated in different rooms. There has already been a rule since the October incident that they're not to be unsupervised. That is what respondent meant separate, to continue the separation that's already implemented. But if this court has any other alternatives, Your Honor, he will follow them. He hasn't seen his child since July 22nd, July 17th, I'm sorry. She's willing to abide by any court orders that the court issues here today.
Very well, Mr. Vasquez. At this time, the court will turn to Mr. Kidwell. Your client's position today, Mr. Kidwell?
My client's position, based on facts that were not disclosed during that presentation, is that he should have supervised parenting time. And I want to explain that this is not the first incident. And I want to explain Mr. Vasquez was talking about the text messages. I'm going to ask the court to go to bait stamp page 23, which was part of the text exchange. And this is between, obviously, my client Haley and Zach. And on bait stamp page 23, Mr. Vasquez was correct. He keeps asking every day to see the child. My client responds, quote, "Zach, you have known about this for approximately 10 months. I only learned about it 2 weeks ago because you didn't inform me, despite me being Ember's mother. I have serious concerns for Ember's safety. You took action when Cincinnati was reportedly touched by his mother's cousin's son, and they no longer have any contact. Why is Ember's safety concerns being treated differently?"
And this is where the hearing takes a dramatic turn. Until now, the father's side had portrayed this as an isolated incident between very young children, followed by immediate safeguards. But the mother's attorney is now claiming something much bigger, that the behavior happened repeatedly and that Dad knew about it for months without telling Mom. If the court believes that version, this isn't simply a communication mistake anymore. It becomes a serious question about what each parent knew when they knew it and whether the child was adequately protected.
So the reality is that this behavior has occurred numerous times in Dad's home, and he never reported it because he didn't want to get any.
That's my statement of facts. That's not correct.
My witness, Miss Dunn, will testify as to every bit of the entire conversations. We also submitted the videos of Zach admitting that this had occurred previously.
In his
and
home?
It had occurred. Yes, they're included in our exhibits. So obviously there's an issue, and it's a trust issue. You know, he was married to his wife, Gabby, in January of this year, and I don't know what the disconnect is here. If something like this happens, especially if kids are just experimenting, that's, the parents get involved and that's what happens. But when these things have happened before, but you don't know anything about it until the 17th, that's a huge, huge problem. And yes, as a matter of fact, my client said we need to get the child into a therapist. That's on bait stamp 12, exhibit 4, that Ember has been receiving services at South Central Mental Health on July 24th. She's participating in outpatient mental health and community-based services to address ongoing emotional and behavioral concerns. She has a diagnosis of F9 1.8, other specified disruptive, impulse control, and conduct disorder. She demonstrates functional impairments in multiple areas, including functioning within the home, behaviors towards others, mood regulation, and self-harmful behaviors. So, however long this has been going on, that should have been communicated. And I'm not talking in October of last year. It was happening before then with other kids. And then she finds
Your
out.
Honor, again, we would object. That's not true. Anything that petitioner knows has been disclosed by respondent himself. That's simply misleading to the court. And we have to object that that's not true. They've only been together for a year and a half. The incidents that happened with another child were prior to him even knowing the child. Therefore, that's just not true.
Mr.
Your Honor.
Kidwell, the floor.
Thank you, Your Honor. We requested that Miss Dunn be present because starting on date stamp page 29, Exhibit 6, it's a very detailed statement as to what was said, who said it, and what was discussed. And I know that you have read this statement. I can ask her to summarize it or read her entire statement in, but she has skin in the game.
Okay, and what significance does this statement have?
That when they went back in the room and Ember was, Gatlin was yelling and crying, trying to get out of the closet. She'd ripped his shirt off. And so when they sat down, meaning my client, the other Haley, the mother of Gatlin, and Ember was very proud of the fact that she was doing this, and she did it quite often, and she didn't understand why any of it was wrong. And it's a very shocking, absolutely shocking, God bless Ember. She's just telling the truth. But she talks about doing this and what she's learned, and she said she likes to do yucky things with other kids and all the things that a child would say, which means, if you would like me to or allow me to question Miss Dunn, then obviously, but she was there when it happened. They were both there, my client and her. And that's what led to all of this, because obviously my client contacted Zach and said, hey, this just happened. And, Ember says this happens, blah, blah, blah. And it's happened before. And I don't understand the logic that it was okay to not disclose that, because now we don't know how many other children have been involved in this, but we do know that Ember has to have specific therapy now, because it wasn't just a one-time thing. It's been going on, and something has to be done. As I stated, and I respect that Mr. Vasquez objected, my client filed the PFA naming the child Cincinnati, a 6-year-old. She didn't know that she had to name parents, step-parents, etc. That's why no orders were issued, and that matter is still set for full discussion. But in the meantime, if you're a parent and you've been deceived, and somebody says, well, I'll make it all better now, but then there was a prior action and he didn't allow contact with that family or that kid for a year, why does that make it okay now that he decided to say, well, yeah, that happened, but that doesn't make any sense to me. You, as you tell every client, you have a court order, you need to follow it. There's only one exception to that. If you knowingly put your child at risk or in danger, you get charged with felony neglect. That's just the way the law works. So we can try to punish her because she's trying to do every single thing she can to protect their daughter. we're asking for supervised visits. We're asking that we review this after we get to have the PFA hearing, which I've already entered on also. And we go from there. And I obviously need to file an amended with the correct information because my client is not an attorney and she just named the child. But that's what the reality is. And it is a horrific reality. I'm not envious in any way of you having to sit through this hearing. I'm asking for the relief that he have supervised visits. And whenever the therapist, unless the therapist has already told both parents when they both need to be in there for family therapy, she just started on the 24th. But her recommendation is continued participation in therapy to support progress towards these treatment goals and to promote improved overall functioning. In addition, if additional information is needed, participation, treatment, please contact me, blah, blah, blah. The whole point is to go, as we all know, into family therapy, but a child should be able to speak freely to both parents. And this is where we are because my client made the choice to not be later charged for felony abuse or neglect by returning the child when there's no way you can possibly have someone at home monitoring these children 24 hours a day. So she knew that she had to make a choice. I was not representing her. I didn't give her any of that advice. I do know this. These circumstances are not a normal thing where kids are trying to experiment, and this is an ongoing pattern, and we need to protect the child. Thank you, Your Honor.
Good. Well, a couple of questions I'd like to ask you. First of all, how do you know why the protection order was denied initially?
My assumption is because she named a 6-year-old boy, and she filled it out, filed it. Obviously, there were no temporary orders issued, and that's why it's set for hearing.
All right, let me clarify for the record. It was this court that denied the temporary order. I know why it was denied. One, I think you've touched on, the minor child does not have the capacity to be sued. Number two, there was a substantial limitation on a custodial parent's rights, or at least a shared custodian's rights, without that person being a party to the action. That was the second reason a temporary order wasn't issued in the case. And since the case was not assigned to me, ultimately, this court did not feel comfortable with dismissal and rather allowed the case to proceed further, as the course may be eventually, with the assigned judge, Judge Crum. So I just found it interesting that you were making characterizations about why the order was denied without having actually been there and knowing why it was denied. But the second question, perhaps much more important than the first, Mr. Kidwell, what legal authority is your client relying on for the proposition that she could unilaterally deny parenting time to the father when there was a court order which clearly established his time? Your answer? Did you hear my question?
I'm sorry, Judge. You cut out at the end.
What legal authority did your client have to deny Mr. Rodriguez his court-ordered parenting time?
And now the judge cuts straight through the emotional arguments and asks the question that really matters legally. What authority did the mother have to stop the father's court-ordered parenting time? Her answer is essentially that she was acting in the child's best interest, but the judge wants something more specific: legal authority. And when counsel can't identify a rule allowing her to unilaterally override the existing custody order, the judge points out the problem. Protecting a child is one thing. Changing a court order without the court is another.
She was acting in the best interest of the minor child.
And what legal authority are you citing that she can make that determination unilaterally and then enforce it?
I'm not.
Okay. So I think you're making a concession. She didn't have legal authority to do so.
Well, yeah, because every person, every attorney, just like every judge, tells their clients to follow a court order. But I wasn't involved in it, so I couldn't have given her that advice.
That would have been good advice, Mr. Kidwell, without a question.
Thank you.
All right. The real issue before the court, folks, today is I think we know that there were some unfortunate incidents involving children in the past. Where do we go from here? This court does not see that any failure to disclose by Mr. Rodriguez constitutes some forfeiture of his parental rights. It does not. I think the better practice would have been to disclose each and every incident to the other parent. That is the nature of joint and shared custody. Clear communication on anything important, and I can't think of much more things that would be more important than what happened here involving these children and their incidents. It's also clear that the child in this case needs therapeutic intervention. That's already been recognized. It's already been set up. This court will order in this case that this child continue with therapeutic services as recommended by South Central Mental Health Counseling Center, and the parents are both ordered to participate either individually or in joint sessions as directed by the therapist connected with her case. I have had cases in the past where a parent simply did not think it was appropriate or necessary for them to be involved. Not here. Both of you will ultimately be part of the solution for this child and part of any development or healing which is necessary concerning this child. So you need to be very much involved with the therapeutic process to the extent that the professionals recommend. Second of all, I think it's inappropriate to continue to deny the father from having parenting time with the child. There were other workable alternatives. Why not give him a couple of hours at the park, away from this child entirely? There is no evidence before the court that Mr. Rodriguez himself is an actual perpetrator or an actual danger to his child.
And here comes a ruling. The judge finds no evidence that the father himself was an actual perpetrator or a direct danger to his daughter. So the court reinstates his parenting time immediately. But this is absolutely not a clean victory for Dad. The judge imposes strict safeguards. The children must remain separated. There could be no unsupervised contact, and adults have to monitor them closely. At the same time, both parents are ordered to participate in therapy as recommended. The court's message is clear. Protect the child, but don't eliminate a parent's relationship when less restrictive safeguards can address the danger.
Therefore, his parenting time should be reinstated immediately. However, certain safeguards need to be in place. Part of these, I think, have already been laid out. It's obvious to the court that these children cannot spend any time together unsupervised by an adult. And I don't know logistically how the household's going to work that out. Are you going to keep an eye on one or both children constantly to enforce this? For a while, the court believes it's necessary, or the other child needs to be removed from the household. But I think that if there is adult supervision, monitoring at all times, whether these two are together privately or not, I think that should be sufficient. Mr. Rodriguez understands the problem. He understands the dangers if it's not done. So therefore, they're sleeping in separate rooms, and I think that their situation needs to be closely monitored by the adult in charge at all times. They are not to play together separately unless the adult's there. It's that simple. Now, there may be some therapeutic recommendations made as part of the process along the way, and I'm not really intending to substitute my judgment for a qualified child therapist about how to manage this situation long term. But for now, there needs to be safeguards in place to make sure that these children simply do not have the opportunity to have this happen again. In either household, for that matter. We've got a child that knows more than she should. So both parents have to be forever vigilant about her acting out on any of these tendencies. It's an unfortunate situation, but I believe both parents need to be actively involved in the solutions to the problem. And simply stating that the father has somehow forfeited his right to his parenting time is not part of the best interest of this child, either in the short term or the long term. All right. So with this pronouncement made, as far as the parenting schedule that's currently in place is concerned, where should the child be? Whose week is it, in other words?
Respondent's week, Your Honor.
Okay, can you just use mother or father and get away from this whole petitioner and respondent thing, which I think is just more confusing than helpful?
Absolutely. It's father's parenting time this week, Your Honor.
All right.
This week?
Or has the schedule been so disrupted that people can't keep track of it?
We've been week on, week off. And
They had a 2-2-3 in the 2021.
on the 7th is my week.
Starting the 7th of August.
Yes.
Yes.
Okay. But unless I'm mistaken, it's August the 5th.
Yes. So it's his week now.
And then the judge takes this ruling from the courtroom to real life. There's no waiting for another hearing. The judge orders the child to return to Dad's home that very night. The exchange is set for 5 p.m., and Dad is told exactly what the court expects. Separate rooms, constant adult supervision, and absolutely no unsupervised interaction between children. But perhaps the most important instruction comes at the end. The parents are told not to involve their daughter in the legal battle. She needs to be allowed to remain a child. After weeks apart, the judge is trying to restore the parenting schedule while keeping the safety restrictions firmly in place.
Okay, I want this child in Dad's home tonight. Mr. Rodriguez, are you in a position to be able to take her?
Yes, Your Honor.
Are you in a position to be able to carry out the safeguards which the court has outlined, including strict adult supervision and keeping these two apart unless there's the adult right there to supervise? Are you in a position to
And
be able
you've,
to do that?
Your Honor, you've stated separate rooms, not just separate beds.
That's correct. They need to sleep in separate rooms, even if they need to be temporary accommodations. Children
Your
are
Honor,
quite sleeping
sorry.
rooms. Much
They do
more.
have separate rooms.
All right. That's part of the court's expectations and demands here. If Mr. Rodriguez is in a position to be able to take her tonight, I see no reason why he shouldn't finish out his week. And let's go back to this to the schedule.
Where will you meet
It's in
today?
place.
So I can meet at the police station in Rose Hill.
My client says she can meet him at the police station in Rose Hill today to exchange a
Is that their
child.
normal exchange point?
Huh?
Is that their normal
exchange point?
No, I think the normal is he normally picks her up at my house.
Okay.
So
Do you just want him to come and pick her up at the house then?
It'd be easier for the child if he did.
yeah.
Yeah. And what time are you going to do this? It's 20 till 4.
Takes me about 40 minutes to get home.
Okay. So by 5? Okay. By 5, Your Honor, if that's okay with Dad.
Rodriguez, 5 o'clock?
That
Haley's
works for
house?
me, yes.
All right. That's when the exchange will be made. You'll keep her for the rest of your normally scheduled work week or visitation week. And I understand that turnover is going to be relatively quick, but I think under the facts and circumstances of this case, it's probably consistent with the best interest of the child. She's been away from your house for a little while. Mr. Rodriguez, you just need to be mindful of that and try to be the most understanding and that you can be with her situation. Hopefully she doesn't really know what's going on in court.
My
I
client
wouldn't try
has
to
not
discuss it
discussed
with her,
anything.
Dad. Just let her know that you missed her and that you're glad that she's with you. That seems to be enough. All right. Judge Crum will deal with the protection order in due course, I presume, and make an appropriate final order of some kind when that matter is scheduled to come to court. So with this current set of orders in place, I'm going to need a volunteer to draft the order stemming from today. Mr. Vasquez, you're going to do that?
Yes, Your Honor, absolutely.
Please do. Get that over to Mr. Kidwell as soon as you can, including that reversed exchange time for Friday night. What's the normal exchange time on Friday evening?
Your Honor, it varies
30,
by
I
my
mean, it
work
really just
schedule.
depends when he goes by his work schedule.
Yeah. My client says they've agreed on 4:30, but they've always done it by whenever his work schedule. So if it's a little before or if it's after that, they've always agreed to that.
Let's set a time this time, a little bit later in the evening, Mr. Rodriguez. 6 o'clock?
Yeah, I can do that, yes.
Very well. 6 o'clock, Friday. And I really would admonish the parents to try not to involve the child in the legal proceedings. Just let her be as innocent as she can be under these circumstances. Just let her be a child and enjoy both parents' homes again. But under close, watchful eyes. I just hope there's
Thank you, Your Honor.
All right. All right, counsel, is there a need for any further scheduling in this particular case? Mr. Vasquez?
I don't believe so, Your Honor.
Mr. Kedwell?
No, Your Honor. No, Your Honor.
If you can, counsel, I'd like to see the order stemming from today in the court's queue this week.
Absolutely.
Very well. I appreciate counsel's endeavors in that regard and for your passionate arguments on behalf of your clients here as part of these proceedings. After all, it's the best interest of a child that we're trying to promote here while respecting the constitutional rights of both mother and father to parent. I perceive currently before me, we have two caring parents that love their child, but part of that is working with and communicating with the other parent. Good luck in that regard, because in this case, it's absolutely critical. Very well then. If there's nothing further at this time, this matter will currently be in recess, and this meeting may be ended for all at this time.